My name is Mr. A. Small, and I am Senior Counsel for the Respondents, Product PLC. I'm assisted by my learned friend, Mr. J. Hay, who will be addressing your Lordships on the second half of our submissions. Before I begin, I would request your Lordship's permission to be questioned during our speeches, as it is the way that we are prepared to answer.
We may well ask you questions at the end as well.
That's fine, my Lord, but any questions you have during our submissions, feel free to ask. My Lords, my submissions are as follows. Firstly, that Section 36 of the Administration of Justice Act 1970, as amended by Section 8 of the Administration of Justice Act 1973, would not apply in this case, because the conditions for its application have not been fulfilled. Secondly, that the case of Mortgagee and Barclays Bank PLC was correctly decided by the Court of Appeal and should be affirmed. There are no grounds to reinterpret Section 36 of the Administration of Justice Act so as to give it effect in instances where no action has been brought for possession. Thirdly, any attempt to reinterpret Section 36 would be to go beyond judicial interpretation and amount to judicial legislation. Such a change would undoubtedly act to alter the current balance of the competing interests of borrowers and lenders, and such a policy decision is a task for Parliament and not the courts. Finally, I shall address the arguments of my learned friends opposite, but the principle in Mortgagee is in fact contrary to the rights of a mortgagor under the Human Rights Act 1998. It is our submission that this argument is incorrect for the reasons I shall explain. I shall begin my submissions by establishing the foundations of the law in this area, initially with the legal basis of the right of a mortgagee to take possession, which has been called into account by the appellants in their skeleton argument. My Lords, it is well established law that since 1925 a mortgage of freehold land has taken effect as a demise for a term of years absolute, subject to proviso for redemption. The effect is that the mortgagor demises his immediate estate to the mortgagee, who thereupon becomes entitled to possession by virtue of the estate which he has acquired. This possession is a common law right and not a remedy given by a power of the court. A modern authority for this principle is to be found in the dictum of Justice Harman in the case of Four Maids Limited and Dudley Marshall Properties, found at page 35, volume 2 of the 1957 All England Law Reports, which is tab 7 in your bundle of yellow tabs. It should be known. The quote is in his first paragraph, Harman J, and starts by Justice Harman. The right of the mortgagee to possession in the absence of some specific contract has nothing to do with default on the part of the mortgagor. The mortgagee may go into possession before the ink is dry on the mortgage, unless, by a term expressly or necessarily implied in the contract, he has contracted himself out of that right. He has the right because he has a legal term of years in the property. So long as certain payments are made, he will not go into possession. Then he has contracted himself out of his rights. Apart from that, possession is a matter of course. The principle for this statement has been met with wide approval, including by the Court of Appeal in Mortgagee, and is often viewed as epitomising the position of a mortgagee in this case. As such, subject to limitations I shall outline later in my submission, if the lender defaults, the mortgagee, in accordance with his common law right, can obtain possession without the need for a court order, as long as it is carried out peaceably. However, in many cases this is not an option, for it is likely the mortgagor to be in occupation of the property. It is in these circumstances the mortgagee has to obtain an order of the court to vacate the mortgages, and not otherwise. In order to exercise their right to possession, in order to realise their security, the mortgagor, in response to this, the mortgagors will rely on Section 36 of the Administration of Justice Act. Section 36 acts as a limited defence for mortgagors in such proceedings, as it allows the court to suspend or adjourn possession proceedings, but does not act to extinguish the mortgagor's right to possession. It is our submission that Section 36 would not apply in the present matter, as the conditions for its application have not been met. This is clear upon a literal construction of subsection 1, which states that the court may only exercise its statutory powers under subsection 2, and I quote, where the mortgagee under a mortgage of land which consists of or includes a dwelling house brings an action in which he claims possession of the mortgage property. It is clear from the construction of this section that this interpretation is the only conclusion possible from the wording. It stands to reason that if the powers given in subsection 2 only arise if an action is brought, they cannot arise in situations where an action is not. For example, as in the present case when the mortgagee exercises their common law rights directly upon the property. I use as persuasive authority on this interpretation the Law Commission's 1986 working paper, number 99, paragraph 3.69, which, my lords, is the last pink tab in your bundle. Oh, not pink, green. Apologies. yellow tab 13 on that page, paragraph A. May I assist the court in reading this section?
Yes.
The court can exercise its discretion only if the mortgagee applies to it for a possession order. Technically, therefore, the mortgagee can deprive the mortgagor of protection by electing to seek some other means of enforcement. In practice, of course, it is rarely feasible to do so if the mortgagor is in occupation and refuses to leave. The effect of this interpretation proves my earlier point, my lord, that section 36 can only apply if an action is brought. This authority was also cited in the case of Mortgagee.
Can I ask you just to pause? I'd like to read that paragraph again.
Yes, my lord.
Thank you. Thank you.
This authority, my lord, was also cited with authority by Lord Justice Chadwick in the case of Mortgagee itself. This is found at tab 1 of the bundle, the first yellow tab, where he cites the same paragraph I've just referred to lordships to. Sorry. This clearly demonstrates that the interpretation as favoured by the Law Commission is in fact the current legal interpretation as favoured by the courts. Page 8 of the report, of the A4 report. As Lord Justice Chadwick has cited this with approval, it shows, my lords, that the interpretation I have offered is the correct one.
Where are we looking?
It's the, as you go down the page, it's the second paragraph, the indented one. Which, I know my lords, it's not it. It's the third paragraph up from the bottom. The beginning A, the court can exercise. The language of this section, as well as the circumstance in which it's cited, and strong support of the Law Commission's working paper number 1999. They also, my lordship, also cites the report of 1991 for authority. And there is also, a few down the page, he references academic commentary further, emphasising our interpretations being correct. Do your lordships have any further questions on this point of my submissions?
Not yet. We will read this through. I appreciate you may have done this already, but what conclusions you've drawn from that last paragraph on
The Law Commission report or working paper?
the Law Commission report.
The Law Commission report and also the working paper which led to the same report, my lords, lend strong support to the conclusion which I've already expressed, that section 36 can only apply if the mortgagee applies possession.
Yeah.
Because it says that the section 36 wording says that there needs to be an action in order for the powers under subsection 2 to apply. These authorities are good and then strong support to the contrary position that if the mortgagee does not apply through the court but exercises a self-help method, then the court has no power. Because subsection 1 has not been fulfilled and so subsection 2 cannot apply. Do you lordships have any further questions on this point?
No, thank you.
I shall then move on to my second submission on this.
Thank you, Steve.
My lords, it has been argued that this literal interpretation of section 36 provides an anomalous result, namely that a mortgagor is more protected when a mortgagee brings an action than when they utilise self-help tactics. My learned friends opposite have made numerous emphatic submissions on this point, but this is in fact contrary to the principles of law. In response to this same argument, the appellants in Mortgagee argued that section 36's meaning should be reinterpreted as so that it required that all claims of possession should be brought by court action. It is our submission that such an interpretation is not possible given the wording of section 36. In response to this argument, Lord Justice Chadwick embarked upon a thorough analysis into whether or not the statute could be so reinterpreted. He began by following a purposive method of statutory interpretation, firstly by establishing what the law was before Parliament legislated, the problem or mischief that Parliament was trying to provide for, and what remedy Parliament was trying to effect. His Lordship began by looking at the genesis of Section 36, holding that its purpose was to overrule the principle creating the cases of Birmingham Citizens Permanent Building Society and Court, and 4 Maids Limited and Dundee Marshall Properties Limited from 1957. These cases are found at tabs D and G. D and H. If I might direct your Lordship's attention to tab 10 in the bundle, the yellow tab.
Shall I keep this page D open?
It's page 10 is the relevant section. Tab 10. Apologies. Mr. Justice Russell held at page 182, which was in the paragraph that begins with the words accordingly. Whereas here, the legal mortgagee under an instalment mortgage, under which by reason of default the whole money has become payable, is entitled to possession, the court has no jurisdiction to decline to make the order or to adjourn the hearing. My lords, my learned friends opposite have also relied on the same quote, but they appear to have misinterpreted the word mortgagee and mortgagor in this case, as they have quoted if the mortgagor cannot be persuaded to agree to this course, which is the fourth line, which is in fact a mortgagee. This illustrates that it is the mortgagee's decision whether to prosecute the possession and has no bearing at all on the mortgagor's wishes. The mortgagee has to agree to prevent. This was the previous common law position under this case. Lord Justice Chadwick argues, in response to this rule...
Can I ask you just to pause there?
relevant section of this report is found at yellow tab number 1 and is being quoted in the case of Brunel. Is the section there. I'll read out the most relevant section. The Payne Committee considered the court should have a discretion to adjourn the application, or, if an order of judgment for possession is or has been made and not executed, to stay or suspend the application of any such order or judgment, or postpone the date of possession for such a period as the court thinks fit. In consideration of this statement, and also of statements made by Lord Justices Scarman and Goff in Western Bank and Schindler, Lord Justice Chadwick concluded, and he says this at tab 2 underneath. And the quote I shall assist the court with begins with the phrase, "There is nothing," which is 7 lines down in the third paragraph. There is nothing in the circumstances leading to the enactment of Section 36 of the 1970 Act which provides any foundation for a submission that it was intended to deal with a different problem, not then identified, arising from entry without an order of court. Nor is there anything in the language of the section itself which lends support to that submission. If the section had been intended to deal with the problems arising from entry without an order of court, it is to my mind inconceivable that the section would have been enacted in the form which it was. I may also direct your Lordship's attention to tab 8, which is a quote from the case of Western Bank and Schindler, where Lord Justice Scarman considers reinterpretation of Section 36. Would your Lordships benefit from a summary of the facts of this case?
Well, sorry, where are you asking us to...
Tab 8, my lord, yellow tab number 8, Western Bank and Schindler, page 12 of the A4 report.
Okay.
He considered that there were 3 courts. Would you like the facts, my lord?
Yes,
yes,
yes.
yes.
Okay, I'm sure. By a legal charge dated 4th of January 1973, a dwelling house was charged by the mortgagor to secure the repayment of the principal sum of £32,000 advanced by the mortgagee. The mortgagor let the life assurance policy taken out as collateral security lapse, and the mortgagee sought possession of the property. The decision which came before the court was whether the mortgagor could rely on Section 36 defences in the situation where there had been no default. And this was the matter at issue before the court, whether the Section 36 could be so reinterpreted so that it applied whenever a mortgagee applied for possession, not only in cases where there had been arrears. and that was the reinterpretation that they offered. In response to this, back at tab 10, Lord Justice Scarman considered there were 3 courses open to the court. First is to treat the section as having a causus omissus, which only Parliament can fill. The second, which, my Lords, is most relevant to our case, and that for which counsel for the defendant principally contends, since it would give him victory outright, is to treat the section as excluding the common law right to possession from mortgages of dwelling houses. The third is of no consequence to our case, my Lord. He goes on to say, in response to this, at the second paragraph from the bottom, my Lord, he considers the second course that he's considered.
And which page
No, page 12, my Lord, the 4th full paragraph down.